Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi, and I along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing procedural criminal law contained in Bharatiya Nagrik Suraksha Sanhita 2023, and in this session we would discuss trials. Now, before a crime is committed, executive magistrate, SDM, DM or police may take preventive measures so as not to let the crime happen. So, executive magistrate, as we have discussed in other session, that he would call people by summons etc. and would ask them to furnish bonds that they would keep peace or that they would show good behaviors. Under section 127, 128, 129, 126, 7, 8, 9. Police may also take preventive action. So, under section 170 BNSS, this is also BNSS. Under section 170 BNSS, if police officer is of the view that somebody is going to commit a cognizable offense, then police may arrest him even if he has not yet committed a crime. So, these ideas are before a crime is committed. Once a crime is committed, the preventive action idea is then obsolete, of course. Now, the person who has committed crime is to be punished, convicted by a court and punished thereupon. This idea is meant exclusively for judicial court, So, no executive court, no SDM, DM, no police officer can punish a person for having committed a crime. Punishment is the idea which is the prerogative of judicial courts. And judicial court, for punishing somebody, holds trial. We have in India, we have adversary trial. In an adversary trial, there would be two adversaries, as the name suggests, state on behalf of victim and the accused. So, state with all its might, all its resources at its disposal through its investigating agencies, first would investigate the crime and then would file a report before the judicial magistrate, and then in the court of judicial magistrate through public prosecutors, it would conduct the prosecution. So, in a trial before a judicial court, one party would be the public prosecutor and the other party would be the accused, who would be represented by a defense lawyer, by an advocate. Now, we have n number of provisions in BNSS which ensure fair trial to accused. Say for example, charge is framed by the court, not by PP. For example, court may call its own witnesses. If required, the court may also call its own witnesses. There are impartial judges. Impartial judges would preside over the case. They would be free of any influence of executive, free of any influence by executive, as in by the state. So, our system envisages separation of judiciary from executive. We have open court, so anybody can go and watch the proceeding. we have presumption of innocence. So, unless somebody is convicted by the court finally at the end of trial, unless convicted, he shall be presumed to be innocent. In fact, even if somebody pleads guilty at the charge, we will discuss what charge is and when it is framed by the court, as I said. Even if somebody pleads guilty at the stage of charge, he may still be tried, by the court. The court may not convict him directly on the basis of his plead guilty, but then he may still be tried by the court so as to eliminate any possibility of pressure, influence, etc. upon him. We have right which has been given to the accused to fully know his case. So, a copy of challan, charge sheet or police report has to be provided to the accused before he participates in the trial, so that he would know what the case is against him. Then only he would raise his defense. If he does not know the case about him, how can he raise an efficient defense in his favor? And of course, that he would be represented by, so legal aid also, if he is indigent, etc., or unable to engage a lawyer, then legal aid shall also be provided to him. So, every effort has been made to provide an equal level field for both the parties in a trial. Now, in the subsequent sections that we discuss, we will have their practical implications, what are the provisions, what kind of trials are there, who holds those trials, etc., that we would see. Now, to start with, we would discuss today these 4 chapters, that is trial before a court of session. We have already discussed that the hierarchy of criminal courts is High Court, Court of Session and Court of Judicial Magistrate. Magistrate here means judicial magistrate. Executive magistrates do not hold trial, as I said earlier. Now, we have a trial that is to be held by session, and we have these trials to be held by magistrates. This trial also to be held by magistrate. Now, you see, before we proceed further, let us have an idea of the division of cases. So, for this purpose, the cases are divided in 2 categories. One, warrant cases. What are warrant cases? These are the cases where punishment is more than 2 years, So, if suppose theft is punishable up to 3 years, then it would be a warrant case. Second type of cases would be summons case. So, here the punishment would be equal to 2 years or less than 2 years. Now, with this categorization in mind, let us try to see what case would be tried by what court. Now, as far as this category is concerned, warrant cases category, now, obviously, warrant cases are more serious than summons cases, isn't it? They are punishable with more than 2 years punishment. Summons cases are less than or equal to 2 years punishment. Generally speaking, it has been observed that warrant cases would be tried by session court or here by magistrate court. Similarly, summons case would be tried here by magistrate, and a band of cases considered not serious to be summarily tried by magistrate. Now, which cases to go to court of session and which cases to go to warrant case, what to magistrate court? Now, this is to be seen as per the schedule appended to BNSS. So, it would tell, so say suppose for example, we have a provision for murder. So, you go to the schedule appended to BNSS and there would be columns, as I said in other session also, murder, whether it is cognizable, non-cognizable, bailable, non-bailable, and here you will find the triability. Who tries it? Court of session or judicial magistrate first class or judicial magistrate second class. So, if you see murder in that schedule, it would be tried by court of session. So, these warrant cases would be divided in court of session or magistrate as per the schedule appended to BNSS. And if you look at the schedule, it would appear that more serious offences have been given to court of session. So, murder, rape, dacoity, etc., they have been given to court of session. Remaining warrant cases had been given to magistrate here in trial of warrant cases. So, here also we are looking at warrant cases, here also we are looking at warrant cases, but the difference is that these are more serious warrant cases, these are lesser serious warrant cases. Now, similarly here also summons cases, those cases as I said which are less than equal to 2 years punishable are to be tried by magistrate, and when you look at the schedule you will find that generally such cases are tried by magistrate. Again we have to look at the schedule specifically to know whether it is triable by which court, and a band of less serious cases also tried here. Special category of cases, petty cases. These are known as petty cases. So, here these are lighter offences as in these are summons cases, and these are even more lighter offences, and also as we have seen most serious crimes, lesser than that, and the least serious crimes. So, from here to here the seriousness is decreasing, and hence the trials are getting less and less elaborate, as in this trial would be very elaborate, this would be lesser elaborate, and this trial is in fact, as the name suggests, the trial would be a summary trial. So, the details would be lessened as we move from the elaborateness of the trial would lessen as we move from here to here. So, that would be evident when we would discuss the different trials. Now, let us start with the trial before a court of session. So, this is the most serious crime which is being tried here, as I said. So, this is chapter 19. Now, the first section says that such trial shall be conducted by a public prosecutor. Of course, the prosecution shall be conducted by a public prosecutor. Now, before moving further, let us discuss this idea also. As I said, High Court is also a criminal court. If you see section 6, you will find High Court as a criminal court. If you see section 21, it says High Court may even try the offences, But as we have seen here, High Court has not been envisaged anywhere. It is only court of session, magistrate first class and second class, as the case may be when we look at the schedule. So, it is only the court of session or the magistrate courts, judicial magistrate courts. High Court is nowhere. But then, as section 21 and section 6 would provide that High Court may also try, as we have discussed earlier, it would be an extraordinary situation, a rare situation that High Court would be doing that, and if the High Court does that, then the trial would be as accordance with this procedure only, as we are going to discuss. So, this procedure, which is trial before a court of session, would apply not only to the court of session, but also to the High Court, as per section 520, unless the case falls under section 447 BNSS. So, as we have seen, the trial shall be, in the trial the prosecution shall be conducted by a public prosecutor. Then it says opening case for prosecution, section 249 BNSS. It says when the accused appears or brought before the court, in pursuance of a commitment of the case under section 232, as we have discussed in a separate section, that the challan by police, even in a session tribal case, session tribal as in when we look in the schedule, the offence has been shown to be session tribal in those columns here. So, if suppose murder here is shown to be a session tribal case, then the challan would still be filed before the magistrate court. Magistrate court. Challan would not come directly into the session court. Challan would first be filed before the magistrate court, and then the magistrate would be committing the case to court of session. This is called committal. Now, if such committal has been done, then the prosecutor, so when the accused appears in that case before the court of session now, earlier he would appear before the magistrate, now he is appearing before the court of session in the trial. So, when he appears before the court, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. Here, he need not to give full details of his evidence, but as an idea, as in what evidence actually he is going to produce, would thereby he would be opening the case. Also, that's something which has not been mentioned here. When the accused appears, it must be that the court of session should ensure that he has been supplied with the copy of challan. Copy of challan has to be supplied by the magistrate, as I said, under section 231. It is the duty of magistrate to supply challan to him and then to send him to the court of session. But then it has been observed in many cases that the court of session should ensure that the accused has received a copy of challan. Discharge, section 250. Now, the copy of challan has been given to the accused, he comes to the court and prosecutor opens up the case. Now, it says, now the first step now would be to charge the accused or to discharge him. This is the first step that would happen, and we say that the trial start with framing of charge. So, if somebody is discharged here, the trial would not start. So, it says that the accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232. The magistrate would commit the case. Within 60 days of that committal, the accused may prefer an application for discharge. Earlier, this provision was not there in CRPC. Now, this discharge idea to specifically provide for the arguments that the court should decide the application for discharge, that this provision has been added to make it onerous on the court that it would decide that application whether to discharge or not, that this provision has been introduced. Then it says, so if upon consideration of the record of the case and the document submitted therewith, and after hearing the submissions of both sides, the judge considers that there is not sufficient grounds for proceedings, then he shall discharge the accused and record his reasons. Now, here in Ajay Parmar case, Ajay Parmar 2012 Supreme Court, that the court observed that at this stage, accused is not supposed to produce evidence, not supposed to produce evidence. This stage is meant to examine the material against the accused filed by challan and to see whether it raises strong suspicion that he had committed the crime, that the accused had committed the crime. If it appears that he had committed the crime and there is strong suspicion for that based on the material produced by the police, then the person would be charged of those offences, those sections which appear to have been committed by the accused. As I said, accused is not supposed to produce his evidence. Why? Because this stage cannot be turned into a mini trial. A mini trial. It is the symptom of a trial where both sides would produce evidence. Now, this stage is of framing charge or discharging him. So, it should not be turned into a mini trial. The idea is to look at the allegations, and if allegations are holding substance, then the person should be charged. So, what defense counsel would do at this stage, what accused would do at this stage, would not produce his evidence, but then he would find the lacuna. So, from his side he will not be producing the evidence, but he would be picking up the lacunas in the challan, and on that basis he would say that the story written in the challan is unreliable. It cannot be a natural story. I mean, it is unnatural what the police is saying, and so let me be discharged. That is the idea that the defense counsel would be giving to the court, not that his own defense that he would be producing in the court. Having said that, the courts have also observed that even such evidence may be produced, such evidence as in accused evidence may be produced in a rare case, at the stage of framing of charge, if such evidence is of sterling quality. Sterling quality means that evidence would destroy the prosecution story altogether. So, if the evidence is of that quality that it would actually raise down the prosecution in one stroke, then such evidence may be allowed to be produced from the defense side also. Now, let us quickly come to the next slide. It says framing of charge. So, if somebody is not discharged, charge would be framed against him. So, it says after such consideration as we have already discussed, and hearing as aforesaid, if judge is of opinion that there is ground for presuming that the accused has committed an offence which is not exclusively triable by the court of session, then he may frame a charge against him, or and then by order transfer the case to a CJM or other judicial magistrate, or and thereupon such magistrate shall try the offence. So, if the court of session, after looking at the material, after hearing the arguments etc., finds that the case is not triable by him, then he would send it to the magistrate who would be holding. So, in that case it would be a magistrate tribal case. So, in that case he would send the case to the CJM or any other judicial magistrate and direct the accused to appear before that court. And if he finds that the case is triable by him, then he would frame the charges against the accused within a period of 60 days from the date of first hearing on charge. So, as the case may be, if the case is triable by him, he would hold that trial, frame charge and start the trial. If he finds that the case is not triable by him, he would send the case to a judicial magistrate case, to a judicial magistrate court, CJM or a judicial magistrate first class, as the case may be. Then it says, if where the judge frames any charge under clause B, as in a session tribal case, that the court of session frames charge, the charge shall be read and explained to the accused either physically or through AV means, and the accused shall be asked whether he pleads guilty or not. Pleads guilty or not. Pleads guilty to the charge. So, it happens as in, if you look at the charge, it would say, I so and so hereby charge you so and so under section so and so, sign seal of court, and then it would write question, do you plead guilty? Do you plead guilty? Answer, and the accused would say no, or say the accused say yes, whatsoever he says. It is pleading guilty to the allegations framed in the charge. Then it says conviction on plead guilty. So, if he pleads guilty, then under section 252, he may be convicted thereupon. May, the word here is may, it is not shall. And the idea is again, as I said, that to provide fair trial to him, it may happen that in a murder case, somebody, influenced or pressurized somebody or to save somebody, that an innocent person is pleading guilty to save somebody. In that case, it would be injustice to convict him. So, the court has been given discretion that even if somebody says that I have committed murder, he would still be tried for that murder, and it may not happen that he is straight away punished for murder. Now, once this stage passes, as in discharge, charge, plead guilty, now the evidence starts. So, if somebody does not plead guilty, then the evidence starts. Or if somebody pleads guilty, but the court does not accept that plea, then also the evidence would start. And the first section here is that says that the court will start with prosecution evidence. Why prosecution evidence? Why not defense evidence? Because the basic rule in this context is that the one who alleges proves. So, here who is making allegation against whom? It is the state that is making allegation, that it is the police that is making allegation against the accused, and so police has to prove its case. So, police will start, state would start, PP would start. The one who alleges has to prove, and the one has to prove has to start. So, the prosecution would start, not the other way around. It is not that the defense would start. So, that is the provision here. Then it says, on the date so fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution, provided evidence of witness under this section may also be recorded by audio, video, electronic means. Deposition of evidence, public servant may be taken through audio, video, electronic means. Judge may, in his discretion, permit the cross-examination of any witness to be deferred until any other witness or witnesses have been examined or recalled, etc., for further cross-examination. Acquittal. Now, if after taking the evidence for the prosecution, examining the accused and hearing the prosecution and defense on the point, the judge considers that there is no evidence that the accused committed the offence, the judge shall record an order of acquittal. Now, if we compare this provision with the later provisions that we will see in magistrate trial, warrant trial by magistrate, such provision is absent there. The idea here of pronouncing acquittal even before defense evidence. So, defense evidence has not been conducted yet, but the accused is being discharged. The idea is that if the prosecution is not able to stand on its feet, the prosecution is not able to prove his case. As I said, the one who alleges, he proves. So, if the prosecution fails, I mean there is no substance in their evidence, then the judge may acquit the accused. One more thing you must be knowing, that once a person is charged by the court, he would only be either convicted or acquitted. His fate would either be conviction or acquittal. Other such words like dismissal of a case, discharge, etc., they are not legal words in this context. Discharge may happen only at the stage of framing of charge, that he would either be discharged or charged, but once he is charged, he would either be convicted by the court or acquitted by the court. Now, the idea of having this kind of acquittal here at this stage is that because Court of Session would be holding serious matters, most serious matters, and it would be an elaborate process. So, why to put the burden of litigation, the stress of being an accused in a case for a long time upon the accused? So, without any further ado, that the judge would acquit him. One thing. Second thing, which if you see closely, because these are most serious offences, murder, rape, etc., the idea is not to make the accused disclose such persons who would be coming as witnesses from his side, because the crime is serious here, and if the accused is asked to conduct his defense, as in to conduct the evidence on his side, then he has to call witnesses from his side, and then it would create friction in the society. Friction in the society, because one group of persons would be like officially or formally they would be on the prosecution side as prosecution witnesses. Other group in the society, if the accused conduct his defense evidence, there would be some people who would be deposing on his side as defense witnesses. So, in that case, formally and openly that they would be deposing in his favor. So, there would be rifts in the society unnecessarily. So, to avoid that possibility, without calling the evidence, the case, the accused is acquitted, and also as I said that the prosecution has not been able to stand on its feet. So, that is why also the accused has been acquitted at this stage. Now, if the accused is not acquitted at this stage, of course, then the defense evidence would start, and then it says if accused is not convicted under section 255, that is, then he shall be called upon to enter on his defense and adduce any evidence. If he puts any written statement, judge shall file it with the record. If accused applies issue of any process for compelling any witness or production of any document or thing that we have already discussed in one session, the judge shall issue such process unless he consider it to be frivolous. Arguments. When the examination of the witness is complete, then the prosecutor shall sum up his case and the accused or his advocate shall be entitled to reply. Now, here we are holding oral arguments, So, once the evidence stage is over, the two parties would be arguing the case, then it says that the judgment of acquittal or conviction would be passed. Finally, the judgment would be passed, it says, after hearing arguments and points of law, if any, the judge shall give a judgment as soon as possible within period of 30 days. Then it says if the accused is convicted, the judge shall, unless he proceeds in accordance with section 401. This is where the accused is released on probation or after admonition. So, instead of sending him to prisons, he is released on probation or after admonition. Then it says here the accused on the question of sentence. So, unless he is considered here under 401, he would be heard first and then would be sentenced. Now, hearing the accused is an elaborate idea, Simply putting some formal questions to the accused, you want to say anything about your punishment as to what punishment should be awarded to you, you have to say anything, he says no, that is all, that would not do. The idea is that the court would make every effort to know as to what sentence would be suitable in that case. So, his social background, his family background also, educational background, etc., whether he was first offender or not, what circumstances that led to his committing crime, etc. The sociology of the crime shall be considered here. Also, that if the court thinks fit, even evidence may be led in that respect. So, that is why we say that it is a bifurcated trial. Till here, it was for conviction, and at this stage, and it would be a separate inquiry altogether, that what sentence would be most suitable, previous conviction. Now, here the idea is if somebody has been previously convicted, then he would get a severe sentence, more severe than otherwise as he would have got. Now, let us quickly look at trial of warrant cases by magistrate. Now, we have come to the magistrate court. And here we are looking at two categories actually. A, that is cases instituted on a police report. These cases would be those where an FIR has been registered, case was investigated, police report is filed, challan, charge sheet filed, court takes cognizance, frames charges, magistrate takes cognizance, magistrate frames charges, and magistrate holds trial. Now, this is when it says that in any warrant case is more than 2 years punishable. In any warrant case instituted on a police report, see, here is the police report. It has been filed before the magistrate. The accused appears or is brought before a magistrate at the commencement of the trial. The magistrate shall satisfy himself that he has complied with the provisions of section 230. Section 230 is, it says that a copy of challan shall be given to the accused. So that again, as we have seen in court of session, that he would come to know as to what actually the allegations are against, what is the case against him. Now, once this copy of challan is given to the accused, again the stage of charge discharge would come, right? Again, similarly as in court of session, charge discharge. Again here, accused may make an application for discharge within a period of 60 days. And then it says, upon considering the police report and the documents, etc., if any of the accused, either physically or through audio video means, as the magistrate thinks necessary, and after hearing them, if the charges appears to be groundless, as in the allegations here, allegations contained in police report, challan, charge sheet. Though charge sheet is a misnomer, because charge is always framed by the court. You see, charge is always framed by the court, as we are looking at and we are discussing. But this report which is filed by the police is called in practice charge sheet, which is a misnomer. The actual name of this report is police report, as denoted in BNSS. So, challan, charge sheet are its name of practical relevance. So, then again, considering the allegations, whether they are baseless or hold substance, not to let accused to produce evidence, unless of course of sterling quality, the magistrate would decide whether to frame charge against him or to discharge him. So, if substance is found in the allegations made by the police, then the charges would be framed, read and explained to the accused, and then again he shall be asked whether he pleads guilty or not. And again, as I said, this would be charge written here, sections, etc., and then last there would be question and answer. And again it says, if the accused pleads guilty, may in his discretion convict him. May convict, may try. Again, to provide a fair trial to the accused. Then again it says, evidence for prosecution. Then if accused refuses to plead or does not plead or claims to be tried by magistrate, etc., it shall fix a date for the examination of witnesses, may on the application of prosecution issue summons, may deferred until cross-examination may be deferred until other witnesses have been examined, etc., and provided examination may be done by audio, video, electronic means. Then evidence for defense. You see that acquittal stage is absent here. The acquittal that we have seen in session trial is absent here because these are not that serious offences, right? Now, the evidence for defense shall be held here. Again, the defense accused can apply to magistrate to get any witness in the court or to get any document or other thing in the court that we already discussed in other session. Now, we are holding it here. Now, there is a new thing which says cases instituted B, cases instituted otherwise than on police report. Now, here earlier we were discussing that Warrant as in that there would be an FIR, there would be investigation, there would be challan, police report, taken cognizance of by the court, framed charge, and the trial starts. The trial starts. Now, this is one way of doing it. Another way of redressal for a crime is that the victim straight away goes to the court and files a complaint. Now, this procedure is for that situation where there has not been any FIR, not been any investigation, no challan PR. What happened here is that the victim went to the court as a complainant and the court took cognizance of that complaint. And the court takes cognizance of that complaint under section 223 and issues process and calls accused, issues process against him. Accused comes to the court and then this process starts. So, it says when any warrant case, and the case is warrant case. Warrant case means it is punishable with more than 2 years punishment. If the case is more than 2 years punishable, the victim made a complaint before the court directly, there has not been any FIR, etc. and the complaint has been taken cognizance of and the court finds substance in the complaint and calls accused, as we have discussed in other session, and the accused now is standing in the court. Now it says, in any warrant case instituted otherwise than on a police report. Otherwise than on a police report generally means on complaint. The accused appears or is brought before a magistrate. The magistrate shall proceed to hear the prosecution. Brought before means, say, suppose court issued summon against the accused. The accused did not come. Then the court may issue warrant also against the accused to call him in the court. Section 90. So, now he appears himself, of course, in response to the summons or is brought before by the police upon warrant. The magistrate shall proceed to hear the prosecution as in the complainant here and take all such evidence as may be produced in support of the prosecution. This is called pre-charge evidence. Pre-charge evidence. The idea of holding pre-charge evidence is, now if you compare this procedure with the court of session or judicial magistrate warrant trial procedure, you know, this is what? Judicial magistrate warrant case on complaint trial. Earlier we were discussing judicial magistrate warrant trial, warrant case on police report trial. Now we are discussing judicial magistrate warrant case on complaint trial. Now in earlier trials as in court of session trial and judicial magistrate on police report, judicial magistrate warrant case on police report trial, that we have seen that the trial first step would be in that trial procedure to give a copy of challan to accused. Copy of challan to accused so that he would know about what the case against him is. Now here there is no challan because there is not been any investigation. Now the idea here is that once the accused comes to the court would hold a pre-charge evidence so as to make the accused acquainted with the allegations against him. Now once that is done, now he knows about the case against him, the accused would be either charged or discharged. This is similar as we have had already seen. Discharged if upon taking all evidence, no case against accused. Now section 269, it says if substance is found in the pre-charge evidence, then he would be charged against. This charge shall then be read and explained to the accused. And now here for the first time that the accused would be having an occasion to cross-examine the witnesses earlier examined by the complainant, because earlier they all were either before he appeared before the court or that he was not allowed to take part and cross-examine them. Now he would be cross-examining them, and Then it says that if there is any remaining witness for the prosecution, he shall next be called, cross-examination, etc. That would happen. Then evidence for defense, section 270, then the accused shall enter upon his defense. Then conclusion of trial. Now, we have seen warrant case, maybe on police report, FIR investigation challan, or on complaint directly, that is before the court, no FIR, no investigation, nothing. Now, we have seen the two procedures. Now, they merge here, converge here at section 271, and now we are heading towards the conclusion of trial. So, this conclusion of trial is for both this case as well as this case. It says that if the accused is found not guilty, acquittal, and if he is found guilty, then he would be proceeded here under section 364 is where he cannot pass sentence sufficiently, as in he is not competent to pass sentence of that magnitude, then he would send it to a higher court, or section 401, that is about releasing on probation or after admonition. And of course, we talk about the previous conviction, and because of the previous conviction that he would be getting a more severe sentence. Absence of complainant. Now, it says when the proceeding has been instituted upon complaint and on any day fixed for hearing, complainant is absent and the offence may be lawfully compounded or is not a cognizable offence. Then, giving 30 days for the complainant to be present, the court may discharge the accused if he does not come further. The idea is that such cases which are like compoundable, as in wherein compromise may happen, or which are not cognizable indicates that they are lighter offences. So, if in such offences and they are such offences and they have been instituted upon complaint. So, somebody instituted a complaint in a court. In such cases, either they were compromisable or they were lighter offences, not cognizable ones, and he himself does not come to the court after filing the complaint, then the court may discharge the accused in that case. And then it talks about compensation for accusation without reasonable cause. So, if somebody makes an accusation against somebody, that is, he would be liable to give compensation for the person accused, and it would be happening in all the cases, as in instituted upon complaint case or upon police officer. Direct payment of compensation, in default, simple imprisonment. If he does not pay compensation, then this provision applies to summons cases as well as warrant cases. Now, let us come to the third trial. So, this is summons trial. Summons trial is those cases which are less than equal to punishable with 2 years by magistrate. Court of session would not be trying such cases. Here, charge is not framed. It is only that the substance of accusation is stated, and if he pleads guilty to that accusation, the court may convict him thereupon. Procedure when not convicted is where that the magistrate shall proceed to hear the prosecution, take all such evidence, and then make all PWs, and then acquittal or conviction. If magistrate upon taking evidence and such further evidence, if any, cause to be produced, finds the accused not guilty, shall record an order of acquittal, not guilty, acquittal. And this is for non-appearance or death of complainant. In a summons case, if the complainant does not appear or dies, then it says that the magistrate shall give 30 days if he is absent, time to the complainant to be present, and then if he does not come present, then the accused would be acquitted. Withdrawal of complainant. If a complainant at any time a final order is passed, satisfies the sufficient grounds for permitting to withdraw, the magistrate may permit him to withdraw and shall thereupon acquit the accused. power to stop proceeding. These all provisions that we are currently discussing are for summons cases. They may not apply to trials of warrant cases. It says in summons cases instituted otherwise than upon complaint. So, it would be a summons case instituted upon a police report, that is there has been an FIR investigation, etc. That case is also possible. So, say for example, if it is a case against under section 262 BNS, it would be showing resistance or obstruction in somebody's lawful apprehension. So, if A goes to arrest B and B shows resistance unlawfully, illegally, 262 would be committed. This case is punishable up to 2 years under section 262, but it is a cognizable offence. Now, every cognizable offence may be FIR may be registered, investigation may be committed, and then police report may be filed. So, it would be a summons case on police report. A magistrate first class with previous sanction of this CJM stop the proceedings, for reasons to be recorded, stop the proceedings.
The idea here seems to check the police access in summons cases.
Now, this is section 282, which says a summons case can be tried as a warrant case. Those summons case which are offence punishable with exceeding 6 months. So, they must exceed 6 months, the punishment should exceed 6 months, and if appears that it wants an more elaborate process, then it may be converted into a warrant case trial. Summary trial, power to try summarily. It says notwithstanding anything, any CJM or any magistrate first class. So, judicial magistrate second class generally cannot try summarily. If they try, then it would be under section 507 BNSS, the trial shall be void, because judicial magistrate second class have not been mentioned here. So, these magistrates CJM and JMIC can try summarily the following offences: theft where value of property does not exceed 20,000 rupees, assisting in concealment of this stolen property where the value of such property does not exceed. Now, see, theft is something which is punishable up to 3 years. But if the value of the property which is stolen does not exceed 20,000 rupees, then it becomes a summarily triable offence.
This is the idea upon which this band of cases has been conceptualized to be tried summarily in this section.
And it says that after giving a reasonable opportunity of being heard, reason to record, try in a summarily way, and then a summary trial by second class. Only those second class who are the High Court may empower them to do so. Otherwise, they cannot hold summary trial. Procedure. It says summons case procedure shall be followed in summary case also. Plus this restriction that sentence not exceeding 3 months only can be passed. So, that is the restriction here, that only 3 months imprisonment can be passed maximum. Then it says record in summary trial. This record will be kept: serial number, date of commission of offence, date of report or complaint, name of complainant, name, parentage, etc. This record shall be maintained. Finding, sentence or other final order, date on which proceeding were terminated, and a judgment shall. So, this judgment is in addition to that record, in addition to this record, and a judgment shall then be passed containing a brief statement of reasons, of course, for finding, and it would be written in the language of the court, of course. Thank you.
Hello, I am Professor A.K. Sharma and I teach sociology in IIT Kanpur. I am taking up a question, what is word population crisis? World population crisis refers to explosive growth of population which occurred during 1950s and 1960s. For millions of years, some people estimate that perhaps man appeared on this planet Earth 5 lakhs years ago. It took these 5 lakhs years for world population to reach first billion in 1820 AD. And that means that the population in ancient times must have been rising at rate 0.0000 something percent per year. Now, in 1950s and 1960s in the world, you find that population started growing at rate more than 2% per year. This is what is meant by population crisis. You can imagine that if a population grows or anything grows at 2% per year, then in about 35 years time it can double. And obviously, particularly in the context of less developed countries, it had implications for poverty removal, for employment generation, for maintaining health, improving life expectancy, raising educational levels, etc., etc. The reason behind this population crisis was improvement in life expectancy or improvement in general health standards of populations. You may not be knowing, or you will be surprised to know that about 100 years ago in our country, life expectancy means average age of death or average age of life, whatever you say, of a newly born child was only 20 years, and today it has reached the level of 68 years. Much of this improvement in less developed countries occurred in 1950s and 60s, and therefore, with improvement in health, improvement in life expectancy or average age of birth, average age of death, population started growing at explosive rates, and people started writing about this. This is population explosion, or this is population crisis. And now one can say that the period of peak growth rate is over, and from 1971 onwards in the world as well as in our country, growth rate of population has started declining. Now, in India, you may like to know what is the current growth rate of India's population. Currently, India's population is growing at 1.5% per year, and the reason is that after sudden or unexpected improvement in health conditions in 50s and 60s, which led to population crisis, we find that today average number of children has also started coming down. So, there was a time when average number of children per woman was around 11 or 12, now it has come down to 2.5, and therefore, the growth rate of India's population has come down to 1.5%, and we can hope that in the future, means in the coming decades, even if nothing changes on the front of fertility or number of children, India's growth rate of population will decrease further and eventually come to a zero level, as said by the 11th 5-year plan of India. And now the major cause of high growth rate of population is not high fertility, but the age distribution of population. So, we have a high percentage of population at the younger ages, and that is the cause of high rate of growth of population. Eventually, when population of India will also age like population of other developed countries, our growth rate will start falling. Thank you. Now, we will meet in the future.